There's a case moving through the courts right now that I think exposes a gap in the way we talk about legal certainty in surrogacy. I'm not going to get into the disputed facts of the case. There's a newborn receiving cardiac care. Every party has legal representation, and there's still a lot that we don't know. But there is one issue this case raises that I haven't seen many people talking about, and I think intended parents and gestational carriers need to understand it. So, in both independent and agency supported surrogacy, intended parents are generally told some version of this. Work with a reproductive attorney licensed in the state where the birth is going to occur, get your pre birth order, make sure your parentage is established. And yes, absolutely do all of those things. But there is a limit to the protection that paperwork can provide. On July 27th, the Alaska Attorney General filed a statement of interest arguing that Alaska's constitutional privacy protections cover a gestational carrier's decisions about where she receives prenatal care and where she delivers, and that neither a contract nor a court can make those medical decisions for her. So think about the impact of that. You can plan for a birth in a surrogacy-friendly state, hire an attorney there, obtain a valid pre-birth order there, and you still may not have the ability to determine where the baby is actually born. That distinction matters. A contract can say where a delivery is supposed to happen, but if that term is breached, the remedy may come after the fact. The contract itself doesn't necessarily give anyone control over a medical decision in the moment. And most people will never encounter this issue. But when something goes wrong, the difference can become incredibly important. And I don't think the takeaway here is that surrogacy is somehow unsafe. I also don't think the takeaway is that gestational carriers should have fewer rights. I think the takeaway is that we need to stop giving people more certainty than the law can actually provide. Intended parents really deserve to understand where the paperwork stops protecting them. And likewise, gestational carriers deserve to understand where their medical autonomy may extend beyond what their agreement appears to say. Those conversations should happen before an embryo transfer, not in the middle of a medical crisis. And at Pineapple Family, we believe being transparent about the complicated parts of surrogacy really makes journeys a lot stronger. Pretending those complications don't exist, they don't help anyone. So we recently published a framework for understanding what actually makes a state surrogacy friendly. That answers an important question. Can you obtain a parentage order there? But this case raises another question, and that's what happens when that parentage order is tested across state lines? That's the follow-up we're working on now. And one last thing, because it matters, every party in a surrogacy journey should have independent legal counsel, not shared counsel, and not attorneys whose independence you simply assume. Independent counsel for every party, with everyone understanding exactly what their agreement and court orders can and cannot do.